It's just getting messier. The Alec Baldwin trial ended in such a mess, with the case being dismissed against him 3 days into the trial. And you're thinking, well, it's already over. Why is it getting messier? Well, not for Special Prosecutor Kari Morrissey. It ain't over for her. I think it's getting messier because she's spilling some tea. She's saying that her co-counsel, Erlinda Johnson, well, the reason why she quit that day was because out of self-preservation. Not only that, but she's also saying the judge may have erroneously dismissed the case against Alec Baldwin because she misunderstood some testimonies. And how exactly did all of this go down? I'm going to read the judge's written order because she gave a verbal one on the last day of trial, but we now have a written one where she has all of her thoughts fleshed out on paper. And with that, I'm going to also include clips of the trial as well. This is like a recap of what went down. And then we'll get into Special Prosecutor Morrissey's response to the Hanna Reed's case, because her attorney, her defense team, Hanna Reed, they want her to have a new trial. And with that response, Kari Morrissey, she'd be, I don't know if she sounds a little bit unhinged, but there were definitely some moments in there where I was laughing. I wasn't laughing at her, I was sort of laughing with her. I like reading these because sometimes attorneys, judges sometimes even, will throw some snarky comments towards the other side. For example, Ben Chu had some really good ones when he was going after Amber Heard and her defense counsel team. Okay, shall we get started? I want you guys to take note of the date, 7/31/2024, because we'll see when Kari Morrissey wrote her response to the defense, because I don't think she saw this at all. So they had an evidentiary hearing during trial because on day 2? I think it was on day 2, crime scene technician Popple, she went up there and testified. And when she was being cross-examined by the defense team was like, didn't someone come in and turn in some ammunition? And that's what pretty much started the whole thing. They had an evidentiary hearing. They heard from 5 witnesses. It was crime scene technician Marissa Popple. That was one who started everything. Corporal Alexandria Hancock, Seth Kenny, there was a lieutenant, and Special Prosecutor Kari Morrissey. Why did she testify? Anyways, if you guys forgot who these people are, don't worry, we'll have some refreshers throughout the video. So some factual backgrounds. The court goes through how both sides are supposed to turn in discovery, right, to each other, and there's a deadline for that. Now, throughout pre-trial, the defense team complained so many times about the state, about how they failed to comply with the court's order. So there's one where June 24, 2024, there was a late disclosure made by the state relating to the expert witness reports and statements by expert witnesses. These reports and statements bore the functionality that the firearm that discharged the bullet that killed Ms. Hutchins. Now, the court found that the state had culpably made late disclosures, but they denied the motion on grounds the defendant had not established materiality or prejudice as defined in relevant case law. All right, so that's one. On June 24, 2024. Now, this is where I hopped into the pretrial stuff, and I remember hearing about this. I think it was like right before jury selection, how there was thousands, 150,000 pages of documents that wasn't turned over from the state to the defense. Again, another issue, but the court was like, all right, the state, you guys screwed up here, but we're going to deny the defense's motion. Now we have a third one. The motion to concern late disclosures made by the state in relation to expert witnesses' statements, and also asserted that discovery issues relating to witness statements remained ongoing in the days leading up to the trial. So y'all can see the dates are getting closer and closer to the trial date. We're in June 2024. Oh, you can see my mouse? Oh, there it is. Sorry about that. We're getting closer. The trial was starting, I think, on either the first or second week of July. So we're getting really close to the trial date, and we're having some issues here. Now, what's interesting here is that now between June 27 to June 27 to 29th, 2024, co-special prosecutor Erlinda Johnson, a former federal prosecutor, disclosed over 1,100 pages of discovery that Morrissey had previously refused to provide. Yikes. Kari Morrissey is a special prosecutor for the Alec Baldwin case. She was also the special prosecutor for the Hanna Reed trial as well. And she's actually not a state prosecutor. She's a private attorney. She has her own law practice. I read that her background was in civil rights and criminal defense attorney. She was hired as a special prosecutor to come help and assist the state. Because sometimes, maybe they need help with the workload. Sometimes there might be some issues, conflict, things like that. Now, Erlinda Johnson, her co-counsel, is also a special prosecutor, but she jumped on a couple months before the Alec Baldwin trial started. Here's the fourth one on June 27, 2024. The defendant filed defendant Alec Baldwin's motion to exclude the opinions of Lucian and Michael Haig. The court denied this motion on the basis that one contested disclosure was not late, all right, and then B, arguments addressing other disclosures duplicated arguments set forth in previously filed motion. Now, the court is saying, ultimately, the defendant's filing discussed above demonstrate that the state continually made late disclosure to defendant throughout pre-trial litigation, and even in the days immediately preceding the jury trial beginning July 9, 2024. Nevertheless, on July 1, 2024, the state filed a certificate of compliance in which Special Prosecutor Morrissey stated that she had transmitted to counsel for defendant, pursuant to the provisions of Rule 5501, all materials and documents in her possession, enumerating the provisions of Rule 5501 for disclosure by the state. So she signs this certificate of compliance saying that she turned everything over. Oh boy, well, that's exactly not what happened, is it? We have jury selection, the trial starts with opening statement, and then in day 2, we have the testimony of CST Popple, crime scene technician. On July 11, 2024, CST Popple continued her testimony in the presence of the jury. Defense asked CST Popple about the ammunition submitted to SFSO by Good Samaritan near the conclusion of the trial of State v. Hanna Gutierrez.
At that trial, this issue of did Seth Kenny really provide the ammunition to Seth or not, right?
Yes, I believe that came up.
Okay. And a Good Samaritan walked into the police station and gave you the lethal ammunition, didn't they?
After the Hanna Gutierrez trial, there was an individual that came to the police station and stated they had ammunition.
And they turned in the ammunition?
Yes.
And they gave it to you, right?
Yes.
And they told you that this was the ammunition that ended up with Seth Kenny that killed Miss Hutchins, right?
I do not recall all of their statements.
Okay, but you didn't, he told you it had to do with the Rust shooting, correct?
Yes.
Defense's cross-examination further elicited testimony that SFSO inventoried the ammunition and a supplemental report concerning the circumstances of the collection of the ammunition in a non-Rust investigation case number. And this is when we are watching this trial as it unfolds, we're wondering, is the defense trying to throw at everything and see what sticks? Is this just something that's like frivolous? Is this dumb? Or is this going to go somewhere? I don't know. At this point, I think our ears were perking up a little bit.
Isn't it the case that law enforcement likely has the matching rounds to the ammunition that killed Miss Hutchins?
I do not know.
And you do not know because you made a doc report about this and did not put it with the rest of the Rust evidence, correct?
Those rounds were not placed with the rest of the Rust evidence, correct?
Nor were they sent to the FBI for testing with the Rust evidence, were they?
No, they were not.
I have no further questions for this witness.
He's like, I'm done with you. I'm done. Defense elicited further testimony from CST Popple establishing that defendant was not given the opportunity to inspect the newly connected ammunition when defendant inspected ammunition inventoried under the Rust investigation case number. So defense came to look at the evidence, and the one that was inventoried under the Rust case number wasn't brought to their attention. They didn't even tell them about it. They didn't even get a chance to look at it. It just seems really bad. But you see, this is where I'm wondering, how long has the defense known about this? Because Jason Bowles at some point must have disclosed to them, hey, Troy Teske turned over some ammunition to the police station. Did you guys by chance know about this or anything like that? I just want to know, how long has the defense known about this? Because I think Morrissey thinks the defense has known this for quite some time and they're prepared to set this up during trial. I just wonder, when the defense learns about, there might be some evidence that wasn't disclosed to them in a proper timely manner, can they hold and wait until trial to bring it up, or do they have to address that right away? Either way, it's the state's fault.
Are you aware of whether the sheriff's office ever informed the defense that a Good Samaritan came in and turned in this ammunition?
I do not know.
When the defense came to view the Starline brass nickel primer live ammunition with you didn't show them this, did you?
I did not have an evidence viewing with the defense. That was my coworker.
Your coworker didn't show this to the defense, correct?
I do not know.
Do you have any reason to believe your coworker sent this to the defense, given that it wasn't put in the same inventory as the Rust case?
No.
On redirect, the prosecution identified the Good Samaritan as Troy Teske, a close friend of Hanna Gutierrez Reed's father. Now, Troy Teske, we thought he was going to testify in Hanna Reed's trial, but he ended up not testifying. The defense ended up calling him.
And let me ask you, Ms. Popple, the ammunition that the Good Samaritan, Mr. Teske, the close friend of Hanna Gutierrez's dad, when he That ammunition that he brought to you after her conviction, you still have it?
Yes.
You can bring it in here and you can show it to the jury, right?
Yes.
And they can see for themselves that it does not match the live ammunition from the set of Rust, correct?
Yes.
And that is obvious just when you look at it, is it not?
Yes.
And this is going to be a huge issue because she wasn't telling the truth. Either on purpose, maybe she forgot. Who knows? Following CST Popple's testimony, defense alerted the court to their intention to file a motion regarding the state's failure to disclose to defendant the supplemental report and make available the Teske supplied ammunition for review by defendant. The state's argument primarily focused on the purported provenance of the Teske supplied ammunition. Special Prosecutor Morrissey proffered. I don't have a clip of this, so I'm just going to read it. Mr. Teske is Thel Reed's close friend, and Mr. Teske stores Mr. Reed's ammunition. Mr. Teske is a retired police officer who has a bunch of security at his property, so Thel Reed has 300 rounds of live .45 caliber ammunition, and he and Seth Kenny are hired by the producers in the show 1883. So they get hired to do what's called a cowboy training on the set of 1883. So the cowboy training is where gun experts, that being Thel Reed and Seth Kenny, take the actors to shoot real guns with real ammunition. When they originally went to the cowboy training camp in Texas, they'd take all of Thel Reed's ammunition. They took a certain amount of it, and Thel left some in Troy Teske's garage. All this ammunition came from the same place. This is all from basically the same batch of ammunition that Thel Reed had when he got from an ammunition manufacturer in Kingman, Arizona named Joe Swanson. Special Prosecutor elaborated that Thel Reed and Seth Kenny take 300 of his rounds and they do the cowboy training camp. Seth Kenny then takes the leftover rounds back to PDQ. Now, with respect to the Teske supplied ammunition, the prosecution, Ms. Morrissey, further explained that during the initial investigation of the Rust incident, Mr. Teske sent to Seth Kenny a photograph of the sample of the ammunition in Mr. Teske's possession. And that photograph was sent to Corporal Hancock, and Special Prosecutor Morrissey also received a copy of that photograph. The prosecutor proffered, when you look at those photographs, and I'll blow it up for you, you can tell that these are not similar to the live rounds that were found on the set of Rust. I come into this case, I look at the ammunition that was taken from PDQ. I understand from these witnesses that the ammunition was sourced originally from Thel Reed. It was sourced from Hanna's dad. It's not a match. Not only is it not a match when you look at it, it's not a match when you send it to the FBI and you ask them to conduct chemical testing. The photograph that was sent to me is the photograph in the middle. This is not the same ammunition. You can tell from looking at it. It is a different projectile shape. That's not the same projectile shape. That's not the same casing. This isn't a Starland brass casing. It also has brass primers, not silver primers, is what she said. So I disagreed. So I decided I agreed with Detective Hancock that this has no evidentiary value. There's absolutely nothing about the ammunition that Troy Teske had has any evidentiary value in the Gutierrez case. It has no evidentiary value in the Baldwin case. Finally, none of this is exculpatory at all. It is the same exact batch of ammunition that's already been sent to the FBI and tested because it all came from the same place. There's no reason for us to do it again. Back to the court. After argument by the parties, the court conducted an evidentiary hearing. The court ordered the Teske supplied ammunition to be produced for inspection, as well as a previously undisclosed supplemental report prepared in connection with the SFSO's collection of the Teske supplied ammunition. Oh boy. The first witness called was CST Popple. Before CST Popple gave testimony, the court reviewed the undisclosed supplemental report. Of crucial importance, the supplemental report documented that CST Popple collected from Troy Teske 3 Starline brass 45 Colt with silver in color primer, brass in color casings. These are the ones that match the live ammunition on the set of Rust. Oh boy. So like I said, I don't know if Popple forgot, if she was lying, mistaken. I don't know what happened here. Further, the court asked CST Popple to identify the Teske supplied ammunition that fit this description. The court visually inspected this ammunition. This is when the judge came down and she had her gloves on and she was inspecting each one individually.
Where is this box of evidence?
It's in the other room.
I'd like to see it. This is unusual, but if you all don't mind, and if there's any objection, I'm going to have her step down, and when I ask her a question about which is which, she will put it out. Ziegler tested the rounds in the Hanna Gutierrez case, correct?
Yes.
He didn't test any further rounds after the Hanna Gutierrez case?
No.
Okay. In the Hanna Gutierrez case, can you point out what types he did test from here?
I'm uncertain what types he tested.
This is a witness testifying, Ms. Morrissey. Please stop. Do you recognize any of these types of bullets to have been gathered on the Hanna Gutierrez, on the Rust set?
The Starline brass with silver primer are similar to what was collected on set.
And everything that was collected on set went to Ziegler?
Yes.
And at this point, I'm like, oh my God, someone is going to get in trouble. Back to this. The second and third witnesses were called Seth Kenney and Corporal Alexandria Hancock. Both the state defense asked Seth Kenney about questions about the ammunition once possessed by Troy Teske and how some of that ammunition was used during the cowboy training camp for the production of 1883 and how the remaining ammunition from that camp ended up in Seth Kenney's business, PDQ. From this, the defense developed a timeline that A, 45 Colt ammunition was once possessed by Troy Teske. B, some of that ammunition was then possessed by Seth Kenney and Hanna Reed for use at the cowboy training camp. C, Seth Kenney then took the leftovers of the live ammunition to PDQ's business location in Albuquerque, New Mexico. Seth Kenney, doing business as PDQ, then gave purported 45 Colt dummy rounds with brass casings and nickel or silver and primers to Sarah Zachary on or about October 12, 2024, and that Sarah Zachary then introduced those rounds on the set of Rust before October 21st, 2021 incident. So this is just another theory of how these live ammunition could have ended up on the set of Rust. Remember, in the Hanna Reed trial, the initial theory, or the main theory that the state was pushing, was that Hanna Reed was the one who brought them because Hanna Reed said, these are the boxes that I got the ammunition from, and this is the box that I got from my father. But now we have a plausible second theory that the defense is establishing that it could have been Seth Kenney who supplied the ammunition. I am leaning more towards Hanna Reed because of everything that went down in her trial, but this is still very important because it might make the defense approach the case very differently. This is all leading up to the dismissal because the state had evidence that they didn't disclose to the defense when they came over to do the evidence viewing. It was never mentioned to them. It was set under a different case number, not associated with Rust case number. It looks very bad, but there's more. Now we're getting into Corporal Hancock, the lead investigator of this. And if you guys forgot how she looks like, you'll see it very shortly. Regarding the direct examination of Corporal Hancock, the state elicited testimony concerning how the Teske supplied ammunition fit within SFSO's investigation of the underlying incident, why these rounds were not initially collected, and why the supplemental report and collected Teske supplied ammunition were not inventoried under the Rust investigation number. During defense's cross-examination of Corporal Hancock, Corporal Hancock testified that CSC Popple gave false testimony during the second day of the jury trial. That was when CSC Popple said, "Oh yeah, these ammunition looked nothing like the one that was on the Rust movie set." Yikes. Specifically, Corporal Hancock testified that CSC Popple testimony given in front of the jury concerning the attributes of the collected Teske supplied ammunition when compared to the attributes of the live ammunition collected from the set of Rust was false.
Well, you were here for investigator, I'm going to do this again, CST Popple's testimony yesterday, weren't you?
Yes.
And they can see for themselves that it does not match the live ammunition from the set of Rust, correct? Yes. And that it is obvious. Just when you look at it, it is not. Yes. Do you remember that testimony that you were sitting here for?
Yes, I do.
And that turns out to be completely false, doesn't it?
You're correct.
Further, Corporal Hancock testified that once she became aware of CST Popple's collection of the Teske supplied ammunition, Corporal Hancock, Special Prosecutor Morrissey, and Corporal Hancock's supervisor at the time discussed and resolved how to address the Teske supplied ammunition. This part's going to be very, very important because it's going to contradict what Morrissey's saying later on, which is a special prosecutor. Okay, so at this point, when they're aware of the Troy Teske supplied these ammunition, she gets together with her supervisor, with Special Prosecutor Kari Morrissey, And they're discussing what do we do with this? What should we do with this? Oh, okay, well, let's just put this under a different case number. But Morrissey's going to say, oh, I didn't know it was going to be a different case number. They're figuring out what to do and to associate the Teske supplied ammunition with a non-Rust investigation case number. The fourth and fifth witnesses to testify were Lieutenant Brian Brandel, so they were there when Troy Teske came in, and Special Prosecutor Kari Morrissey, who didn't have to testify. Lieutenant Brandel's testimony concerned the circumstances of SFSO's collection of the ammunition supplied by Troy Teske on March 6, 2024. In addition, the court admitted a video recorded from Lieutenant Brandel's lapel camera partially depicting the March 6, 2024 interaction among Lieutenant Brandel, CST Popple, Troy Teske, and an unidentified female. I believe that was Troy Teske's wife.
So did you and Popple have a conversation about what to do with this ammo?
To my understanding, it was that it was going to be put in evidence
Which evidence?
at the sheriff's office.
The Rust evidence?
No.
Why
just,
not?
Just as far in our evidence section in the sheriff's office.
And why was that determination made?
As to why
Who
it
made
was.
it? Let me ask you, who made it?
These were discussions that were had with myself, with the supervisors at that time, and then with the prosecutors.
Were you the lead investigator?
Yes.
Okay. And you said, and with the prosecutors?
Yes, ma'am.
Okay, so you all had discussions about what to do with what he dropped off.
Yes.
And you all agreed to put it in the separate file.
Yes.
Thank you.
Just very brief follow-up on the first question.
We learned from Morrissey's response to the defense that during the lunch break, the court decided to potentially dismiss the case against Alec Baldwin. So now it's really weird to have Morrissey. At this point, you guys notice Erlinda Johnson, she ain't there no more. Where's Erlinda Johnson at? Morrissey's going to be like, oh, hey, I'm going to go up there and testify. And the state's like, are you sure? Why are you doing this? Don't really have to. Okay, I guess you will.
Okay, so just clear, you're a witness, okay? So you can say oath or whatever, but are you calling yourself as a witness? Or do you want Mr. Spiro to call you as a witness?
It doesn't matter to me. How do you want to do it?
I don't think it's necessary, frankly, for this evidentiary record for me to call Ms. Morrissey. I know what happened, and the court knows what happened. I don't think we need anything further.
Okay, do you want to call yourself as a witness? No, well, just a minute. So he's willing, as I understand it, to rest now. Mm-hmm. Okay? Now, you don't have to say anything under oath if you don't want to.
No, I'm happy to.
Okay, so not only happy to, I don't, it doesn't matter to me whether you call yourself as a witness. It doesn't matter to the defense whether you call yourself as a witness. So if you're calling yourself as a witness, there's no one here that's requiring you to be called as a witness.
The information, everything that happened in this regard, especially as it pertains to me, needs to come out in the public.
All right, so you're calling yourself as a witness.
And I am, and it was my understanding that the court indicated to me previously that you wanted me to testify. I understand you've now changed your mind. I think it's a good idea if I do it. Where would you like me?
Okay.
Do you want me here at the podium?
No, on the
Okay,
witness.
sure.
All right, Ms. Morrissey voluntarily calling herself as a witness without any requirement by the court to do so, or Mr. Spiro asking her to. Please raise your right hand.
So if it never left the state of Arizona, the only way that it is relevant to the Rust investigation is if it has any similarity to the live rounds that were found on the set of Rust, because we were, at that point, trying to figure out the source of the live rounds. I didn't have a copy of the report. The rounds that were left at the Sheriff's Department by Troy Teske, I have absolutely no reason to believe that they are relevant to the incident that took place on the set of Rust. These are rounds that were in the possession of Belle Reed and never left the state of Arizona.
You also did not allow the defense to view that evidence at any point during our request to review evidence in this case.
I had never seen it, and I didn't realize that it wasn't under the same case number because I'm not a law enforcement officer and I don't work at the Sheriff's Department. But you are right.
However, this testimony conflicts with that of Corporal Hancock, who testified the SFSO agents and Special Prosecutor Morrissey decided to separately file this evidence apart from the evidence of the Rust investigation. Additionally, Special Prosecutor Morrissey acknowledges that CSD Popple provided false testimony before the jury on July 11, 2024.
Yesterday when Ms. Popple testified, you would agree with me that her testimony under oath was false.
What part of her testimony was false, and I'll answer.
That she said that these rounds don't look anything like the rounds on the set when you elicited that testimony.
I agree with you, and I didn't realize that there were rounds that looked like that.
It's okay.
The court found that the state, Kari Morrissey, violated Brady violation. 1, prosecution, suppressed evidence. Yeah, the Troy Teske ammunition being turned over, and maybe other stuff like the report and the body cam footage. 2, the evidence was favorable to the accused, Alec Baldwin. 3, the evidence was material to the defense, because had they had this in their possession, who knows how they could have approached their defense differently when presenting it to the jury. We're going to go over to Kari Morrissey's response to the state, and she's going to address some things that we didn't know about day 3 of trial in Alec Baldwin. And then we'll get into a little bit of tea with Erlinda Johnson, okay? Oh gosh, Kari Morrissey, I don't know what's happening here. We'll definitely refer back to some parts of the court's documents, but then I'll have all the documents listed down below if you guys want to read this yourself, okay? I recommend read it. Oh boy. Okay, so Kari Morrissey. Now, remember I told you guys to take a look at the dates? The judge filed this on 7/31/2024, 10:44 a.m. Kari Morrissey files her response same day, however, at 10:38 p.m. Okay, so this is in a different case with Hanna Reed. So Hanna Reed's case is already over. She was convicted. She was sentenced 18 months. Now, knowing what happened in the Alec Baldwin case, Jason Bowles, he is Hanna Reed's attorney. And remember, Hanna Reed is the armorer on the set of the movie Rust. They're like, look at all the stuff that went down in the Alec Baldwin trial. We want to have our case to be, we want to have a new trial. And this is Kari Morrissey's response to that. And yes, Kari Morrissey is still on this. They haven't kicked her off yet. Oh gosh, Kari Morrissey. Defendant Gutierrez seems to complain of the 4 issues that she alleges support her motion for a new trial. Okay. First, defendant generally argues that the undersigned counsel lied under oath during a motion hearing during the trial. Kari Morrissey, you good over there? During the trial against Mr. Baldwin, and fails to disclose the existence of ammunition that was obtained from her father's close friend, Troy Teske, in March 2024. Second, defendant raises concerns regarding an audio recording interview of Seth Kenney that was not disclosed until after her trial concluded. Again, Seth Kenney is the owner of PDQ Props. He was the one that supplied the dummy rounds, the blank rounds to the set of the movie Rust. He wasn't working on Rust, but he supplied the all the ammunition and other props. Third, Ms. Gutierrez asserts that she should be granted a new trial because a supplemental report produced by Lucian Haig on August 31st, 22023. I don't know if is she rereading this? I don't know. I feel like she's not. Oh, maybe she was like having a glass of wine when she was writing this. Was not provided to her or her counsel prior to the trial. Fourth, Ms. Gutierrez asserts that she should be granted a new trial because there are unremarkable email communications between the state's experts, Lucian Haig and Brian Carpenter, that was not disclosed to defense prior. Now let's address Baldwin trial and defendant Gutierrez allegations of misconduct. And this is all about, imagine responding to a motion about yourself and that you're the one who engaged in misconduct. So this is Kari Morrissey. Undersigned counsel did not lie under oath. Undersigned counsel testified that she was aware that Mr. Teske provided ammunition to the sheriff's department at the end of the Gutierrez trial. Undersigned counsel further testified that she was not aware that the doc report outlining the fact that the ammunition had been provided to the sheriff's department did not contain the same case number or would not be linked to the same case number as the rest of the evidence related to the Rust investigation. I think that could have probably happened. I think there could have been a miscommunication or some sort of misunderstanding where she doesn't know the processes of the sheriff's department and she just assumed that they're all going to be linked together. Now, what I want to know is that was she there for the evidence viewing when the defense came over to view all the physical evidence? Was she not present for that? Was she present? If she was present, then wouldn't she realize, like, oh, where's the Troy Teske ammunition stuff, right? Who knows? This was a true statement, and undersigned counsel qualified her statement during cross-examination by explaining that she misunderstood that the doc report would have a different case number assigned because she is not a law enforcement officer and doesn't work for the sheriff's department. Corporal Hancock understood that the new doc report would have a different case number because it was a separate doc report. You know, I just feel like, wouldn't Corporal Hancock be like, hey, by the way, like, we're going to have a different doc report. It's going to be under a different case number. It's not going to be tied to the case of Rust. I feel like that's something you would want to clarify because do you really want to put this in a different case number that's not associated with Rust? I don't know. I just feel like that clarification should have happened. Maybe it didn't happen. Maybe it did. Maybe Morrissey's lying. Who knows? We don't know. Undersigned counsel did not understand that doc reports have different case numbers due to her lack of familiarity with the manner in which case numbers are assigned at the sheriff's department. Undersigned counsel and Corporal Hancock testified truthfully. Undersigned counsel testified truthfully when asked why Ms. Johnson, this is the co-counsel, Ms. Johnson, withdrew from the case during the motion hearing. prior to the lunch break on July 12, 2024. And so this is new information here. Without hearing any of the testimony or argument related to defendant Baldwin's motion to dismiss, the court went off the record and notified undersigned counsel and Mr. Spiral, that's Baldwin's lawyer, that she was intending to dismiss the case. Undersigned counsel and Ms. Johnson discussed the issue at great lengths over the lunch hour. Based on the court's off-record statement, it was apparent that the court was intending to dismiss the case, so the state has two choices. 1, dismiss the case on its own volition, or 2, have a full hearing, develop a record, let the court dismiss the case. Ms. Johnson wanted the state to dismiss the case and stated that she wanted the case dismissed out of concerns for self-preservation. I wonder if Erlinda Johnson said that verbatim. She already did an interview and we're going to go over that. But oh man, I'm seeing some jabs over here. Undersigned counsel disagreed that self-preservation was an appropriate reason to dismiss a homicide case, disagreed that the dismissal was warranted under the circumstances, and proceeded to a full hearing. Ms. Johnson did not want a public hearing out of the concerns for self-preservation, and undersigned counsel testified truthfully in this regard. So, this is what happened.
Erlinda Johnson, the next prosecutor selected, resigned from the case today.
She did.
Based in part on the conduct we're here discussing, correct?
I believe that Ms. Johnson Ms. Johnson didn't want my understanding is that she didn't agree with the decision to have a public hearing.
She definitely struggled answering that question. I wasn't sure. Maybe she was trying to answer in a way that wasn't going to make Erlinda Johnson look bad. But Erlinda Johnson, she quit during the trial. She's like, I'm going to have nothing to do with this. And she actually does an interview where she responds to what Kari Morrissey said.
The team said you left the team because you didn't like that this Brady hearing was public.
Absolutely not. Absolutely not. I learned about this evidence when the public learned about it yesterday, late afternoon, that this individual had taken this ammunition to the sheriff's department and provided it to the officers. I learned all of that yesterday when Mr. Spiro was cross-examining the crime scene technician. The motion hearing began. My position was during the lunch hour, before the lunch hour, during the lunch hour, we have an obligation as prosecutors. We have an obligation not only to the people, but to the defendant. Mm-hmm. And our obligation is to make sure that all the evidence is turned over. We don't get to decide what the defense is going to be.
Self-preservation, says Kari Morrissey. I wonder, can Erlinda respond to this? Can she? Counsel has not had a win at all costs attitude in the Rust cases. In fact, it was been the opposite, and Mr. Bowles knows it. Again, Mr. Bowles is Hanna Reed's attorney. Undersigned counsel attempted to resolve Ms. Gutierrez's case with an agreement that would have prevented her from being incarcerated and prevented her from becoming a convicted felon. Presumably upon the advice of her trial counsel, she declined the plea offer, as is her right. Counsel then went so far as to file a sealed motion asking the court to counsel Ms. Gutierrez with regard to the plea offer on the record to ensure her refusal to accept the offer was knowing, intelligent, and voluntary. Court declined to put the plea offer on the record and ensure Ms. Gutierrez understood the consequences of her decision. Similarly, undersigned counsel offered a plea to the misdemeanor to Mr. Baldwin, but rescinded the plea offer when further information surfaced regarding Mr. Baldwin's conduct with material witnesses to the case. This is hardly a win-at-all-costs attitude. Undersigned counsel testified truthfully with regard to the termination of the previous paralegal. Okay, now we're getting some more tea with the paralegal stuff. So remember, Baldwin's attorneys was like, okay, so your co-counsel, Erlinda Johnson, quit on you today. I think it was in Mr. Bowles' motion where he addressed, you see, Miss Morrissey, she's a difficult person to work with. Even her paralegal quit on her. Okay, let's get into the paralegal stuff. Mr. Taub, that's a paralegal, his work was unsatisfactory, and a decision was made that his work would cease after the conclusion of the Gutierrez trial. Undersigned counsel stopped assigning him tasks due to the poor quality of his work, and this resulted with his effective termination. Mr. Taub complained about working conditions as they related to another employee at a DA's office, who he had difficulty getting along with, but never complained about undersigned counsel until he complained that she was no longer assigning him tasks. See State's Exhibit 1, Gladley. Exhibit 1, an email from Kari Morrissey. This is from Harry Taub to someone else. Jennifer, just to close up on the discussion. As mentioned to you, by providing me about 1 hour of work over the past 6 days has effectively dismissed me from the case. This was the choice of KTM, Kari Morrissey, as she is in charge. As I have been left with virtually no work, I needed to seek and obtain other work and mitigate my losses. I do not believe that any course of action other than which I pursued would be proper. I wish you all the best in this matter. You are very clear that my engagement terminates at the end of the Hanna trial, but that assumed that I had work to do, which I have not. This engagement simply has taken place now due to Kari Morrissey's conduct, which has been her choice entirely. I made all the arrangements I was asked to make. Mr. Baca was very helpful indeed. Thank you. It should be noted that Mr. Bowles made mentions of emails and affidavit concerning the issue of Mr. Taub's termination, but attached none as exhibits to his motion. Undersigned counsel will move to strike or, in the alternative, request leave to submit the supplemental briefing should Mr. Bowles decide to submit email affidavits exhibits in his reply. Undersigned counsel testified truthfully that Mr. Bowles did not want the Teske rounds. During the brief statement Mr. Teske made when providing the ammunition to the sheriff's department, he stated that he was asked by defense counsel, Mr. Bowles, to testify on Ms. Gutierrez's behalf and bring the ammunition in his possession to the Gutierrez trial. Mr. Teske did as he was asked, and Mr. Bowles decided not to call him as a witness and not to use the ammunition. Mr. Bowles asked him to bring from Arizona. Mr. Teske specifically stated in his brief statement to law enforcement that Ms. Gutierrez's counsel did not want the evidence he brought from Arizona. It is stunning that Mr. Bowles now claims his client was somehow prejudiced by the state's failure to disclose ammunition that was not in the state's possession, but was in the possession of a defense witness and was available to defense counsel. The January 8, 2024 email referenced by Mr. Bowles had 4 photos of the Teske ammunition attached. Mr. Bowles provided these photos to undersigned counsel. The photos depicted 4 rounds that had brass primers. Only one had Starline brass casing, and all had projectiles dissimilar to the rounds found on the set of Rust. Mr. Bowles is the person who provided undersigned counsel with information that caused her to abandon any effort to obtain or test the rounds. The only information undersigned counsel had about the Teske rounds was the information provided by Mr. Bowles and Mr. Teske, and all the information was that the rounds in Teske's possession was dissimilar to the rounds from Rust. But those are the pictures that were sent over. I mean, if Teske showed up at the sheriff's office with some evidence, I mean, you still got to take a look at it, right? Oh boy. On November 1, 2021, just 1 week after Ms. Hutchins' death, Mr. Teske had the following text exchange with Mr. Kenny, wherein he provided Mr. Kenny with a photo of all the different types of ammunition that he could find in the .45 caliber ammunition he stored for Mr. Reed. The photo depicted 4 rounds, one with a Starline brass casing and a brass primer, on a CBC casing and a brass primer, one with a Winchester casing and a brass primer, and one with a BHA casing and a brass primer. Again, the one that we're looking for is a Starline brass casing with silver or nickel primers. So the photo doesn't depict any of that. 2 years later, in November 2023, Mr. Teske's pre-trial interview was conducted as he was being called as a defense witness at the Gutierrez trial. During this interview, undersigned counsel inquired of the ammunition and considered taking steps to obtain the ammunition from Mr. Teske, but had difficulty determining if there was material evidence. On January 8, 2024, Mr. Bowles provided the following pictures to undersigned counsel and asked if she would send the rounds to the FBI for testing. So here's some pictures, black and white, we can't see the colors. The photos provided by Mr. Bowles on January 8, 2024, above, shows the exact rounds that were photographed and sent to Seth Kenny on November 1, 2021. Only in the photo on the page 6, truncated cone projectile can be seen, confirming that the rounds are highly dissimilar to the live rounds found on the set of Rust. The rounds are comprised of 4 rounds, one with the Starline brass casing and a brass primer, blah, 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 so none of these match. As of January 8, 2024, Mr. Teske was in possession of a .45 caliber rounds belonging to Mr. Reed. None were similar in shape, size to the live rounds found on the movie set of Rust. So Kari Morrissey is wondering, how the hell did Troy Teske get this live ammunition that matched the ones on the set of Rust if he provided them before and it didn't match before? Oh, to be clear, the ammunition in Mr. Teske's possession was owned by Thel Reed, Ms. Gutierrez's father, and there was no evidence they ever left the state of Arizona until Mr. Teske brought them to New Mexico at Mr. Bowles' request during the Hanna Reed trial. They were not provided to law enforcement or anyone in the prosecution team until the end of Ms. Gutierrez's trial. The rounds were not in state possession until March 6, 2024. On November 3, 2021, Mr. Kenny asked Mr. Teske if he located any rounds with silver primers. Mr. Teske responded, no. See photo below. The first time undersigned counsel became aware that Mr. Teske was in possession of rounds that looked similar to the rounds from Rust was the morning of July 12, 2024, because she was under the mistaken impression that the rounds received by the Sheriff's Department on March 2024 were the same rounds from the photos provided by Mr. Teske in November 2021 and Jan 2024. It is highly suspect that Mr. Teske provided rounds in November 2021 and Jan 2024 of rounds that are completely dissimilar to the live rounds found on the set of Rust, confirming in writing November 2021 that he was unable to locate any rounds with silver primers, and then on March 6, 2024, he dropped off similar rounds to those from Rust. So where did Mr. Teske get those rounds from? But here's the thing. I think what happened was Troy Teske dropped off the rounds, and I think because he already was in communication with the state, in communication probably with law enforcement somehow, and they just assumed that, like, oh, these are just going to be the same rounds. It's not going to match. But, I mean, Popple, when she inventoried them, she should have known, like, oh, wait a second. This one has a silver primer. It's also Starline brass. Maybe bring it to the attention of the lead detective. But the lead detective should have checked in on it as well. Same thing with Ms. Morrissey. She should have visually confirmed. Oh, God, what a mess. Ouch. What a mess. This ammunition was never in the possession of Seth Kenney or any other witnesses listed on the state or defendant's witness list in the Baldwin case, other than possibly Ms. Gutierrez herself, but the court was unwilling to compel her testimony. Yeah, remember, we thought that she was going to testify, but we didn't even get there. Undersigned counsel is still struggling to understand how ammunition that was never in the possession of, seen by, or known to any witness being called to the trial was turned over 2.5 years after the death of Ms. Hutchins created a discovery violation that justified a dismissal with the prejudice of Mr. Baldwin's case. So, of course, she doesn't agree with the judge. On the rounds turned over by Mr. Teske, all belonged to Thel Reed, and 3 appeared similar to the live rounds found on the set of Rust. Again, there's no evidence that any of these rounds were in possession of Mr. Kenney or anyone other than Mr. Reed, Teske, and possibly Ms. Gutierrez. Ms. Gutierrez stated that during her second interview with Corporal Hancock in November 2021 that she sourced her dummy rounds from her father. This evidence does not support a sabotage theory. It supports what the state has asserted all along. Ms. Gutierrez brought the live rounds onto the set of Rust after obtaining them from her father, Thel Reed. Moreover, if we were to assume that the live rounds found on the set of Rust were planted there by a saboteur, even though they appear identical to Thel Reed's rounds produced by Troy Teske, it is still this is exactly what I agree with. It is still Hanna Reed's job. It is still Hanna Reed's job, Hanna Gutierrez Reed, whatever her name is. It is still her job to inspect the rounds and to ensure that all the rounds put in the gun for the rehearsal were inert. She failed at this simple task, and it resulted in someone's death. For this failure, she was tried and she was convicted. I'm going to scroll down a little bit and get to this part right here. And this is where I'll go back and forth between Morrissey and what the judge wrote. So this is what defense attorney Jason Bowles wrote. This court stated on July 12th that the integrity of the judicial system demanded that the court dismiss Mr. Baldwin's case with prejudice. How could it be any different with Ms. Gutierrez's Reed case when this proven litany of serious discovery abuses, the intentional withholding of crucial evidence, Brady Giglio by the state has compromised the integrity of the entire judicial process? Oh, this is what Morris replies. The answer to Ms. Gutierrez's question is twofold. First, the question assumes that a court properly dismissed the case against Mr. Baldwin. Although the court's final order has not yet been filed, so she didn't read what the judge had filed here. Undersigned counsel contends that the court misunderstood the testimony on July 12, 2024 and improperly dismissed the case against Mr. Baldwin. Here's what Morrissey outlines. For the case against Mr. Baldwin to be properly dismissed for Brady violation, the court needed to find the following. The evidence at issue must be favorable to the accused, either because it is exculpatory or because it is impeaching, that the evidence has been suppressed by the state, either willfully, inadvertently, or prejudice has been ensued. Morrissey argues the evidence is not exculpatory, as it has nothing to do with the basis of charges against Mr. Baldwin, and it is not impeaching, as Mr. Kenney or any other witness never possessed it or had any knowledge of it. The judge writes, the suppressed evidence is favorable to the accused. The suppressed evidence is favorable impeachment evidence and also potentially exculpatory. For instance, the suppressed evidence was used as impeachment evidence during the defense's cross-examination of CSD Popple. In addition, the evidence is potentially exculpatory. For example, evidence regarding the source of the live round that killed Ms. Hutchins and additional information concerning how the live round arrived on the Rust movie set likely affects the jury's jury's calculus of proximate cause and negligence of a third person or person. The court finds and concludes the suppressed evidence is favorable to the accused. Going back to Miss Morrissey, the state concedes that it was suppressed from the defense because law enforcement was unable to develop any evidence that established the relevancy of the ammunition to Ms. Hutchins' death due to Mr. Teske's unwillingness to provide an interview with law enforcement. So she's saying, yeah, I mean, it was suppressed from the defense. Remember, before she was saying that, like, oh, I thought the case numbers were going to be different. It seems like you knew it was going to be different because Troy Teske never came up to do a follow-up interview. That's why you had it on a separate case file, right? To me, that seems more to make sense of why it went down the way it did. Now let's see what the judge says. First, the prosecution suppressed evidence, which is what Morrissey conceded to. Judge says testimony from multiple witnesses established that the prosecution did not provide the Teske supplied ammunition, the related supplemental report, and Lieutenant Brando's lapel camera footage to defendant. Further, Corporal Hancock's testimony established that SFSO agents and Special Prosecutor Morrissey made the deliberate, intentional decision to place the Teske-supplied ammunition and related supplemental report in a non-Rust investigation case number. Let's see what else Morrissey says. She says, the state further contends that Mr. Baldwin suffered no prejudice as a result of the suppression of the Teske ammunition due to the lack of connection of the ammunition to Mr. Kenny. And the fact that this is where she makes an accusation, the Baldwin team was well aware of the Teske ammunition prior to the trial because they suddenly canceled an evidence viewing in mid-June 2024 and cross-examined Marissa Popple at great length regarding the Teske ammunition. And that's where I was wondering if they did find out that the state didn't disclose some part of their discovery. Is that something they have to bring up right away with the judge, or can they wait for the trial to happen and then hopefully have it dismissed? Because, I mean, even though they waited, at that point, the state still had ample amount of time to possibly disclose it to the defense team. And that didn't happen here. Okay, let's read the rest of what the judge said. Third, the suppressed evidence is material. The disclosure of the evidence during the course of the trial has impeded the effective use of evidence in such a way that impacts the fundamental fairness of the proceedings. Because of this late disclosure, defendant was not in a position to forensically analyze or ask the state to forensically analyze this Teske supplied ammunition as the state had done with other units of ammunition relevant to the Rust investigation. The court agrees with the defendant that the defendant had access to the Teske supplied ammunition before the third day of the jury trial. Defendant would have altered his approach to the preparation of the trial and the trial itself. The court finds the suppressed evidence is material. Oh boy. So a lot of things happening here in Morrissey's response, and there's more. There's a lot more because Jason Bowles addressed a lot of things about Kari Morrissey, what she hid, what she suppressed or allegedly, and it's all in here. There's stuff about Seth Kenney, how there was an interview, and there's a bunch of statements that Seth Kenney made. I already read through all this, but like I said, I'm not going to include this video because I think this video is already super long. I'll have the files down below, but let me know. Maybe if you guys want me to read all of this, I could do like a separate stream. Maybe. This is just a lot to put in a video, but yeah, definitely check this out. And I want to know, is Erlinda Johnson, is she gonna write something? Is she gonna address some of the things that Kari Morrissey said, especially how Kari Morrissey said, well, Erlinda Johnson said that she was doing it out of self-preservation. But Kari Morrissey was like, no, this is a murder trial. We can't be doing this out of self-preservation. We got to move on forward. But, you know, when Erlinda Johnson did her interview with, I think Chris Cuomo, I think is his name, it seems like she was doing the right thing. She was like, hey, like, this is a very fucked up situation. Sorry, she didn't say it verbatim, but, you know, this is a fucked up situation. And I want nothing to do with this, okay? This is not the right thing to do. This is wrong. We're supposed to disclose evidence. We're supposed to do things in a transparent way, in a fair way. Make sure the defendant has a fair chance to fight this in trial. And because that wasn't done, Erlinda Johnson was like, get me out of here. Okay, bye. I'm getting out of here. So I don't know. What do you guys think about all this? This is so crazy. Kari Morrissey. You guys know I really like Kari Morrissey. I do really like her. But man, was she just a huge disappointment during the Baldwin trial. I love that she went up there. I love that she had the balls to testify. And I love that she has the balls to write all this out in her response to the Hanna Reed stuff. I mean, they're going to keep her on, I think, as the special prosecutor for the Hanna Reed. Because, you know, Hanna Reed, I think she's trying to get a new trial, but then it's going to take forever for it to go to appeals. I mean, her sentencing is short in compared to people who are, you know, in jail for like murder, right? Like, you know, first degree murder, stuff like that. She's only gonna be serving about 18 months. And yeah, I don't know. We'll see what happens. I mean, this is a lot of tea that has been spilled. Kari Morrissey, I want to know what the judge thinks. Oh gosh, what a wild ride, y'all. I hope you guys have a good one. Take care. Thanks for watching. And yeah, comment down below, hit the like, and I will see you guys this week. We have Hanna Reed stuff happening. I don't know if I'm going to live stream that. And then we do have another Sarah Boone hearing this Friday. So lots of things going on this week. I hope you guys enjoyed. Have a good one. Take care. And I will see you guys